We have negligence as one of the most important torts in law. So we have Blythe versus Birmingham Waterworks. Negligence is defined as the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or do something which a prudent and reasonable man would not do. So what are the elements of negligence? One, we have a legal duty of care. And this is the duty to take reasonable care to avoid acts or omissions as likely, those acts, those omissions that are likely to cause injury to your neighbor. And this neighbor, not in the strict sense of the word, that is anyone likely to be affected. George, you have asked, can a defense of necessity by a defendant to counter plaintiff's defense of trespass? Yes, we have said whereby it is seen that that was the only reasonable course of action, and any other reasonable person would do that. We gave the example of your neighbor's land having caught fire, and in your land there is an artificial lake, or you have a dam of sorts. You've not allowed your neighbor to access your land. But in this case, they jump over and fetch water from your dam and put out the fire. The question would be, would a reasonable person also deem it fit to do the same? So necessity is where, one, you seek to prevent further damage. You see, this fire could as well spread to your land. But this person has jumped over and has taken bucketfuls of water and has put out that fire. That act is necessary. We use the case of Cope versus Sharp, where the defendant committed certain acts of trespass on the plaintiff's land in order to prevent fire from spreading to his master's land. So the fire didn't cause any damage, and it would not have done so. But the danger was in the fire spreading, and it was real and imminent. So the defendant was not held liable because the risk was real and imminent, and any person would have done what he did. George, I don't know if I have answered your question. Okay, we can proceed with negligence. And in negligence, we have said that there are three elements: the legal duty of care, the breach of the legal duty of care, and the loss or damage to the plaintiff. So what is that duty of care? It's taking reasonable care to avoid acts or omissions that are foreseeable as likely to cause injury to your neighbor. And again, your neighbor is not your immediate neighbor, it's anyone who may be affected by your actions. And the key case is that of Donoghue versus Stevenson, where the claimant, Mrs. Donoghue, went to a cafe with a friend. The friend bought her a drink of ginger beer and ice cream. The bottle of ginger beer had dark glass, so the contents could not be seen. So she drank the ginger ale, and when she poured the rest out, she saw that it contained a dead and decomposing snail. And this appalled Mrs. Donoghue, and she became ill as a result of the sight and the thought that what she was drinking, what was contained in it. So, Mrs. Donoghue had no direct claim against the manufacturer or the shopkeeper based on contract because she did not buy the ginger beer. You remember, it's the friend who bought her the drink. So she had no direct claim from the shopkeeper or the manufacturer. She did not use her money to buy that drink. And while the friend could claim against the cafe, she had not suffered any loss apart from the fact that she had bought defective goods. So she could get her money back, but nothing for the lady who drank the ginger ale that had the decomposing snail. So what did the madam do? She claimed damages against the manufacturer, Stevenson. Her claim was for the resulting shock and stomach upset, which she claimed was caused through drinking the ginger beer. And the court had to decide whether her claim would succeed. And this led to Lord Atkin's famous statement. The rule that you are to love your neighbor becomes in law, you must not injure your neighbor. And your lawyer's question, who is my neighbor, gives a restricted reply. You must take reasonable care to avoid acts or omissions on which you can reasonably foresee would likely to injure your neighbor. So who then is my neighbor in law? The answer is any person so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions called into question. And with this case, this definition of who is my neighbor is where we get that breach of duty of care. And it should fit the three-part test of Caparo versus Dickman, that it is reasonable foreseeable that a person in the claimant's position would be injured. 2, there is sufficient proximity, that is closeness between the parties. And number 3, it is fair, just, and reasonable to impose liability on the defendant. So all 3 must be satisfied if you're to show there is a breach of duty of care. So when we say a breach of duty of care, it means falling below the given standards of care. And it is tested objectively. A reasonable person performing a particular task is expected to perform it to the best of his abilities, that is reasonably competently. So when you're driving your car, you're expected to be, since the assumption is having gone through driving school, you understand the rules of the law, you're expected to be a reasonably competent driver. So for breach of duty to occur, the court takes 1, the degree of risk involved. The greater the risk, the more the defendants have to take care. The cost of precautions. How high is the risk involved? And how expensive is it to prevent that risk? What is the cost of preventing that risk? There's also the potential seriousness of injuries. So if the higher the risk of serious injury, the more the defendant needs to be careful. The importance of the activity. So when it's an emergency, you're not able to sit down and analyze and take the best course of action and all the risks involved. When it's an emergency, you just act. So those will be considered. We also talk about the injury to the plaintiff. So we may prove that breach of duty, but did you get hurt? And would it have happened had it not been for the breach of duty? So in the case of Barnett versus Chelsea, 3 night watchmen went to an accident and emergency room, casualty, complaining of sickness after drinking tea made by the 4th man. A nurse telephoned the doctor on duty, who did not come to examine the men, but instead sent the men home and told them to go see their own doctors in the morning. On returning home, one of the men died a few hours later from poisoning. His widow sued the hospital, claiming that the doctor was negligent in not examining her husband. Evidence showed that by the time the husband had called in on the hospital, it was too late. So what did this show? The death was not as a result of the doctor's breach, and the claim failed. So with the harm that you suffer, could it have been prevented by an early intervention by someone, as was seen in this case by a doctor? So where no doctor could have saved you, then no breach, even if the doctor breached, he's no longer liable for you. And we talk about foreseeability. And foreseeability is the type of damage was reasonably foreseeable. As seen in the case of the wagon mound, where fuel had negligently spilled onto water in a harbor. 2 days later, the oil caught fire because of the welding work being done on another ship. The fire spread to the claimant's wharf and burnt it. So it was held that the damage was not reasonably foreseen. At times, a small act can have ripple effects that are, so to speak, unimaginable. So when it goes way over and above what is expected, the defendant cannot be held liable. And this is what we are talking about. Then we talk about the thin skull rule, whereby you're told to take your victim as you find him. So if the damage is reasonably foreseeable, but something, as we have said, that ripple effect, but because of something unusual about the claimant, such as a thin skull, the defendant is not liable. In Smith versus Lichbrain and Company, where because of a defendant's negligence, a man was burnt on the lip by molten metal. The burn caused him to develop cancer, and his widow claimed against the defendant. And because the burn was a foreseeable injury, he was also liable for the man's death. So the essence is, don't cause harm. You take him as you find him. So we talk about the burden of proof in negligence. It lies with the plaintiff. He has to prove that the defendant owed him a duty of care, that he breached it, and this led into suffering. But it isn't as much. And this is where the doctrine re ipsa loquitur comes. And that is, the facts speak for themselves. And this happens where something is done in a way it not have to be. So it's applicable in negligence if the thing, the injury, was in control of the defendant or over someone whom the defendant exercises control, and it would not have happened without negligence, and there's no way of knowing how it happened. So when the facts speak for themselves, the burden of proof, as I've said, since it lies with the plaintiff, that is what he needs to prove. The defendant had control of what caused the injury. and it couldn't have happened without negligence. So we have spoken about the duty of care and the breach of duty of care. We've spoken about the injury to the plaintiff, and now we talk about the defenses to negligence. So what are the defenses to negligence? One is contributory negligence. And what we mean by this is that both the plaintiff and the defendant had a role to play in that harm happening. And in this, the defendant must show that the plaintiff exposed himself to danger, or that the plaintiff was negligent, and his fault or negligence contributed to his own suffering. And the effect is that it reduces the amount of that is recoverable by the plaintiff to the extent of his contribution. But this defense is not available to children of tender years. You remember they're exempted. Well, they can be sued and can sue. They're exempted in instances where the mental capacity is brought into question. They have no, for this element of negligence, where an act happened and I did something that exposed me and contributed to my own, and a child is removed from this equation. We had talked about volenti non-fit injuria, where you, with full knowledge, we've talked about ending a cricket game, that the bat may fall, the ball may hit you, and you do it voluntarily. You could have chosen to not attend, but you did. You chosen to not park your car in a designated county council park and paid, but you did, and you did it voluntarily. So we have Dan versus Hamilton, where the plaintiff had taken a ride on a vehicle driven by a drunken person, and he was aware of this fact. In consequence, an accident occurred, but this defendant's play of volenti failed since plaintiff had not consented to the risk. You see, the difference is the voluntary assumption. When he accepted the ride, he did not imagine that despite this person being drunk, they would be involved in an accident. His only voluntary act was getting into a car with a drunken person. But in Tagwell versus Anna, the defendant's vehicle expressly stated that passengers rode at their own risk. And the driver in this material case was drunk. The plaintiff, the defendant's defense of volenti succeeded. You see, that element of indicating that you have ridden at your own risk. We have seen company cars that they are expressly written, lifts will not be offered to strangers. So from the onset, you are aware that you should not be in this car, but you voluntarily enter that car and proceed on a journey. Should anything happen, that company is not liable to compensate you, since the warning was there that you're being given a lift, but this vehicle is not allowed, does not have capacity for you to cater for any other person apart from the driver. You know, it expressly states the driver is prohibited from carrying any unauthorized persons. So in that case, there is that volentin and fit injury. You willingly and intentionally enter that vehicle. Should an accident happen, God forbid, you cannot sue the company. You cannot sue the driver. The driver you may sue in a personal capacity, but you cannot sue the company for damages. So a defense to negligence is also the statutory authority, where if a conduct complained of by the plaintiff is authorized by statute and the defendant has acted in accordance with the provision of the statute, the defendant has a complete defense to the plaintiff's action. But the defense is complete and the statute. We talked about railways being built on individual or individual parcels of land. That enables these engineers to come to your land, to set aside where that railway line should pass, and to commence building it. It is a defense for them if they're asked, why are you on this person's land? Then they will say the law allows us to be here.